You should remember in the 50s and 60s, there were very few cases in the courts, in the Supreme Court of India. And in the 50s, my father used to get a call from the registrar of the Supreme Court saying that, Mr. Nambiar, there is a case in which you had appeared at the admission. We do not have any cases for being heard. Therefore, would you be prepared to come and do this case? And my father would say, you please ask my advocate and record to get in touch with me. And then he would go over and do a case. But today, if you go to the Supreme Court on a Monday or a Friday, you will not be able to maneuver your way through the corridor. You would get into the Chief Justice's court at the door, your case is called, and you shout from the back that I'm coming. But by the time you go there, the case would be passed over. You have to fight your way through people. The judges are drowned in the number of cases that they are handling. And I do not think that this is really the function of the apex court of a country to deal with cases other than constitutional issues, other than federal issues which affect states, validity of laws, substantial questions of law which affect the nation as a whole, or the special jurisdictions given in regard to suits between states, state and center, between states and so on. But today they hear land acquisition cases, labor cases, rent control cases, which is a large section of cases, large volume of them. Then very, very ordinary cases where a judge believes that there is some error of law, maybe even an error of fact, I don't know. But you find a rent control case being argued where a plan of a house is being handed over to explain to the court that the landlord does not have enough space for his own comfort and he wants additional space, and he explains as to how. You find matrimonial cases being bitterly fought out. It takes hours. Sometimes the judges call the parties to their chambers because they are human beings. Therefore, they feel sad that this is happening. They want some or other to see whether they can assist in settling this problem. Now, but this is not the true function of a apex court of a country. And that is how the total arrears has gone up during the last 5 years from about 22,000 to nearly 50,000. And you don't see the end of it. And we are now having, as against 6 judges originally, or 7, we are now having...
Now it's the sanction strength is 30.
31 judges. And I remember Justice Matthew in an article said, perhaps we may see the day when the Supreme Court of India will be having 100 judges. For I think that this is a real problem where the government, the judges, have to sit back and then see as to what can be done about it.
What suggestion do you have, sir, to remedy something like this?
Frankly, I am not quite happy about the judgments delivered by the high courts where there are cases which require interference by a higher court. That is because they are perverse. You will find they have not addressed themselves to very important questions which the clients, the party says had been argued. These have been raised but not decided, and they ignore judgments which are binding on them, and so on. Therefore, we cannot possibly say that the High Court, that cases should rest with the High Court. There should be another tier of courts which will deal with the judgments of the High Courts wherever it requires interference. Now, for that, the Supreme Court is not that court. The Supreme Court has to deal only with the cases of the nature which I have mentioned. For I believe that what would be in the interest of the system, the justice delivery system, is to have a courts of appeal. I don't think one court of appeal is sufficient. You have to have 4 courts of appeal in the 4 regions. Northern region, the western region, the eastern region, and the southern region. Now, the chartered high courts have beautiful buildings, very old ones, over 100 years old, with large grounds, many of them. Now, therefore, so far as these are concerned, these could accommodate the courts of appeal. And except for cases which involve questions of constitutional law, difference of opinion between high courts, substantial questions of law which affect the nation as a whole, or matters relating to the validity of statutes, except these sets of cases, all the others will be absorbed by the courts of appeal. Furthermore, I think this system of two judges sitting and deciding in the Supreme Court, I do not think it is conducive to getting consistent justice. That is because, number one, judges are human beings. We have to accept it. But they are trained to be objective. To that extent, their human frailties or approaches would stand diluted. But however, judges have particular leanings based on their own, the environment in which they have been brought up. For example, you have left-leaning judges, centrist judges, and liberal judges. Now, and conservative judges. Now, these are reflected in the judgments. Now, which means that with two judges sitting there, and usually with the senior judge controlling the court and the decision, you will find that it is his views which become the views of the two judges bench, and which therefore become the views and the opinions and the judgment of the entire Supreme Court of India. Which means one judge's views, or even two judges' views, become the views of the Supreme Court. Now, that is scarcely satisfactory. For I believe that they should sit in benches of 5 at least, or 3. And if the courts of appeal are brought into existence, then it would be possible to have 15 judges sitting in benches of 3. The total number of cases would come down from 50 to about 8 or 9,000. They would be able to bring the areas to a reasonable number of 400, 500, which would result in cases being disposed of within say a year and a half of its being instituted. Unless something is done which is drastic, something of this nature, I am afraid that these areas will continue to mount. And how many judges are you going to add to the bench of the Supreme Court? As it is, from 7 it has become, over a period of 60 years, it has become 31. And it will continue to grow. And that's not satisfactory.
So one of the criticisms to the model you've just proposed is that the institutional integrity of the Supreme Court will be affected. How do you address that argument?
See, the institutional integrity of the Supreme Court may be affected if you have benches of the Supreme Court sitting in different cities or different regions, in which case the entire institutional integrity would stand diluted, because here are few judges who represent the entire Supreme Court, functioning in a totally different environment with a totally different set of lawyers and so on. But on the other hand, if you reduce the total number of judges by reducing the area of their functions to these areas which I have mentioned, then I think it will assure you of the institutional integrity rather than the contrary. For example, take the Supreme Court of the United States, Supreme Court of Canada, the High Court of Australia, which is a Supreme Court. The judges sit en banc, which means 9 judges in Canada, 9 judges. That's the entire Supreme Court. They sit together. Now, the result is that the law evolves consistently. There is no sudden leaps and jumps depending upon 2 judges deciding that this shall be the law, expressing themselves totally differently from the next bench. another bench of 2 judges. Now, it means that everything is debated by the entire Supreme Court. And one judge's departure from norms will not affect the evolution of the law. But what is happening today is you find judgments being overruled, judgments being binding judgments being ignored, and so on. Therefore, I believe that there has to be a change.